Hi, good afternoon, everybody.
Good afternoon.
Our session today is on wills. The title of the talk is actually To Will or Not to Will. And some of the topics that we will be covering today is the question, what is a will? And whether everyone should be making a will. And if you are considering making a will, what are some of the things that you should think about? As a start, let me just make 2 points that you should note. What I say today is meant to be for non-Muslim estates. The law is different for Muslims. And secondly, it is meant to be for people who are resident or domiciled in Peninsular Malaysia. Sabah and Sarawak have their own law. Okay, so if you are from Sabah and Sarawak and you are got properties there, you may have to be more careful and you may have to consult a lawyer from Sabah and Sarawak to advise you. All right, so let's begin. What is a will? This is what the Wills Act says in Section 2. It defines what a will is, and it says a will is a declaration intended to have legal effect, blah, blah, blah. All right, you can read that for yourself. Basically, this definition of a will can be broken up into 3 parts for ease of consideration. Okay, so the first part is a declaration intended to have legal effect. A will is therefore a serious matter meant to have the backing of the law. As such, it can only be made by someone over the age of 18 years old. Anyone who's below the age of 18 years old under the law is considered a minor. And a minor does not have the capacity to make a will. A minor does not have a capacity to enter into a contract. A minor cannot hold property in his own name. So it has to be someone who is above 18 years of age at least before he or she can make a will. And the person making the will is actually called a testator. And this person who's making a will, the next prerequisite is that that person must understand the nature and effect of what he is doing. So there must be an intention to make a will, and the person must be able to understand that is what he or she is doing, and to understand what he or she is actually stating in the will itself. Because of the seriousness, the law also sets certain formalities which must be strictly complied with for a will to be valid. A will must be, firstly, in writing. In Malaysia, we do not have video wills. There are some countries that allow you to have video wills, but not in Malaysia. In Malaysia, a will has to be in writing, and it must be signed by the person at the end of the will. So if you sign your will and then you add anything below the signature, strictly speaking, under the law, whatever appears below the signature is invalid. You will notice very often people initial every page of the will. That, I suppose the courts have been a bit lenient on that. And you have to be careful that, strictly speaking, anything below the signature is actually invalid. But most of the time it's saved by the fact that at the end we have a declaration with the signature. So what happens after that will be invalid. A will also has to be witnessed by 2 persons. And these 2 witnesses must sign as witnesses in the presence of the maker of the will and in the presence of each other. So both the witnesses and the person who's making the will, all 3 persons have to be there at the same time to see each other signing. The 2 witnesses must know that it is a will that they are witnessing, but they do not need to know the details of the will. So they do not need to know the contents, but they need to know that they are witnessing the execution of a will. The will must be dated, and this is especially so because most of the time a will state that it revokes all previous wills. It's also to avoid a dispute or uncertainty if you have more than one will existing or found after the death of the maker. An important point to note for a witness is that any gift made to a witness or to the spouse of a witness is void. So if you are going to give something to the witness, then you have to find some other witness, or else whatever gift you intend to give to that witness becomes void and fails. The second relevant part of the definition is with regards to the statement that a will is of the intention of the testator with respect to his property or other matters. A will is therefore meant to be reflective of what the maker of the will himself wants done, and not what other people, whether it's a family or even what the law thinks he wants or ought to be done. And so, subject to any prohibition or limitations against the law, whatever you say is to be expressed in the will and is to be carried out. So of course there will be certain limitations. You can say in your will that I want to be cremated. That's fine. But if you say I want to be cremated and my ashes buried in my garden, that cannot be done because that's against the law, because the law has got limitations as to where your ashes are supposed to be kept and even where it's supposed to be scattered. So subject to limitations imposed by the law, a will actually is meant to be reflective of what the maker of the will wants done. So it doesn't even have to take into consideration what the spouse wants, what the children want. It's the person's personal wish. A will can cover not only the person's property, but also other matters. As I said, you can say that I don't want to be buried, I want to be cremated. Or you can even state the reverse. I don't want to be cremated. So you will find that it is not uncommon for people to state in their wills how they want their remains to be dealt with. But my personal view is I would caution my clients about merely stating their wishes for their remains in a will, because your family may not refer to the will in their grief. They may not want to appear to be so greedy to open up your will before you are even buried, So they may not realize your intention as stated in the will until it is too late. So I actually have a real life case where I actually told my client, you shouldn't put it in your will. You should tell your families about it. But I will put it in the will, but you also have to remind them this is what happens if anything happens to you. So he, in his will, said that he did not want to be cremated. He wanted to be buried. Unfortunately, he went overseas and he died. And it's very expensive to send a body back. So they cremated him and sent the ashes back. And then when they opened the will after that, they found out, oops, Dad said he didn't want to be cremated. But too bad, it's already done. So obviously my client forgot to inform his family that his wishes was not to be cremated. And they only found out about it when they opened the will. So these are some of the practical considerations if you want to talk about how to deal with your remains in the will. Now, the person making the will himself decide who gets what, how much, when, and under what circumstances, and not only takes effect after he dies. The person making the will can also state that he doesn't want so-and-so to receive anything. There can therefore be better protection against a challenge by a dissatisfied dependent who is given a lesser share or excluded. So if you die without a will, the law will prescribe how your property is to be. But in a will, you yourself decide how you want to give it out, who you want to give it to. So you can actually make special provisions in your will for special circumstances. For example, if you have a few children, let's say you've got 3 children, 2 children have already completed their studies, and you have 1 younger child who's still studying. So when you're preparing your will, you may want to say that, okay, my estate will not be distributed until my youngest child has completed his tertiary education. Because after all, you may have paid for your 2 older children to have completed their education. And if you were to distribute the estate upon your death, there may be insufficient funds for your youngest child to complete his or her education. So it is better then, under those circumstances, to postpone the distribution until the youngest child has completed the education. You can also make special provision for someone who is a bankrupt, so that creditors cannot resort to the property to settle the debts. You can also go provision for, let's say, a child who is unable to handle his own finances. You know that whether it's because of immaturity or whether addiction, if you were to give the person immediately a large sum of money, he will squander it away. So in a will, you can actually manage that and to have allowances disbursed at different specific times. You may also have, let's say, a child who has a congenital condition. So then you can make special provision for such a child because there's a special need. So for example, I had a client who had, again, 3 children. The youngest child was born with a hole in the heart. And when he came to see me to make his will, again, he wanted to be fair to all 3 children and say, okay, if anything happens to me, all 3 children will get equally a share of my estate. I then had to question him and find out about his family background, and I found out that the youngest child was born with this congenital condition. So I advised him and I reasoned with him and say, look, it's not a question of whether that child will need medical attention. It's not a question of whether the child will need to go through to correct the defect. It's a question of when. And so if you were to distribute and share your estate equally among your 3 children, your youngest child will be left with very little left after paying off all the expenses for her treatment. And so at the end of the day, he realized that a greater provision needs to be made for that child with the hole in the heart. And so she was given a bigger proportion so that her condition can be treated in the event that anything happened to the father. There may also be special items, for example, a family heirloom or a piece of jewelry of special significance that may be passed on to different individuals. Sometimes we think that, oh, I don't have very much jewelry, so it's fine, we'll leave the children to decide who gets what. But you have to think carefully as to whether perhaps a certain child treasures a particular piece of jewelry for some sentimental reason. Most of the time, it is not an issue of monetary value. It is more an emotional attachment. So in such case, then you may want to be able to say, okay, this particular piece of jewelry is supposed to go to this particular child. That can be done if you have a will. If not, if you die without a will, then everybody is a free-for-all. They take and share among themselves if they can agree, or it has to be liquidated and the proceeds shared among the beneficiaries. Okay. Next, the maker of the will can also decide on and appoint people that he trusts to attend to his wishes after his death. He can appoint persons to manage his business and other affairs, and he can set limits as to what they can or cannot do. And the other person of significance that a person that you can appoint under your will is a guardian. If you die without a will, the people who take care of your estate will be people who have a right to the estate, and they may not be the most appropriate people, perhaps to be running your business or to be managing the estate. So if you have a will, you can decide for yourself who you want to appoint. So for example, I have a client who realized that his children do not get along and they will fight. And they have a large company, business. So in the will, I'm appointed not only as the executor and trustee, but I'm also given the position of being a director of the company, independent director. This is so that the father realizes that the children will argue among themselves, and he trusts me to be there to moderate and to do what's best. So with the will, you can do such a thing. If not, then that is not going to be able to work, and you'll just have to trust that your children will be able to resolve things or end up fighting out in court. I mentioned guardians. Guardians are important for numerous reasons. They actually decide on the child's education. So whether a child goes to Kebangsaan school, whether the child goes to Chinese school, is determined by the legal guardian. And another important thing that a legal guardian decides is actually the religion of the child. So, for example, if you are a Christian and you have young children, if anything happens to both parents, you will want to appoint a guardian who is a Christian so that the child can be raised as a Christian. Otherwise, the child may be raised in some other religion and receive some other religious education contrary to your desires. So a guardian is important, and you can appoint a guardian under your will. Okay, the next limb of the definition is the phrase to be carried into effect after his death. So the important thing to note that a will speaks from the date of the death. It doesn't have any effect before the maker of the will dies. So if you have made a will and you say, okay, I give everything to my son, but 3 years later, you are diagnosed with cancer, and therefore you have to sell off your house, sell off your car, whatever, you can still do it. Although in the will you say that everything was to be given to your son, because it is not a contract, and a will speaks only from the date of death. So if at the date of your death, the house that you intended to give to your son has been sold, it lapses. And your son cannot say, no, you cannot sell the property, don't waste money going for treatment. It's up to you to decide, because a will speaks only after your death. And you have total control of your assets, as it is not a contract. So you can change it at any time. You can update, and in fact, you should regularly review and update your will. Next, let's consider who should seriously consider making a will. Firstly, anyone who has dependents who do not have an independent or alternate source of income to meet their financial needs. For example, if your spouse is a housewife or you have children who are still studying. As they have been dependent on you while you are alive, you have to consider how they are going to manage after you pass on. You have to consider whether you need to make provision for them till alternate arrangements can be made. Making a will shorten the time before they can get access to money. The court process is shorter, and the process of liquidating assets is also shorter. So for example, you may have lots of houses, but if you die without a will, if you want to liquidate one of the houses and sell it so that you got money to pay for your children's education, the person managing your estate cannot just enter into a sale and purchase agreement and hope that it can be completed within the usual 3+1 month. Because there's no authority, and if you die without a will, the administrator who is appointed will have to get the consent of the court. The court will have to review to see whether they should allow you to sell. So that's going to be a delay. You need to get a court order before you can sell. So having a will help you to be able to quicker obtain money to help your dependents rather than making them wait for a long time. So if you have dependents who do not have an independent alternative source of income to meet their financial needs, you should seriously consider making a will. Next, anyone who has surviving parents whose needs are lesser than that of his wife and children. Why? Because if you die without a will, the Distribution Act will step in to divide your estate, and your surviving parents will get a share of the estate, which then means that your spouse and children will get less. I'm not saying you don't need to make provision for your parents, but sometimes our parents are sufficiently well off, and our own children may have greater need. So to have part of the estate given to your parents may render life to be more challenging for your own children. So people who have parents who are still alive and don't have such a great need should consider making a will. Next, anyone with any child under the age of 18 years. As I mentioned earlier, anyone below the age of 18 cannot hold property in their own name, and they cannot legally consent to liquidate any assets. So if you were to die without a will, and you have children below the age of 18, the property will have to be held in trust for the children. It will also partly go to, perhaps if you got your your parents who are still surviving and your wife who's still surviving, they will also get a share. But because the children also have a share, everything will be jammed because you can't just sell as you wish. You'll have to go to the court to get permission to sell. So this will take time and it will cost money. And the courts may even consider it imprudent and require you to try and obtain other means of income for your children rather than liquidating your assets. So the complications involved. So if you are in such a situation where you have children under the age of 18, it is best to have a will so that you can avoid such complications. Next, anyone who has dependents who have special needs, including illness, financial difficulties. You can make special greater provision for them. For example, you can set aside some money for an inevitable surgery in the future. Remember the client I mentioned about the child who had a hole in the heart. It's not a question of if, but when she will need to go for surgery. So you can make special provision. You can set aside a certain amount of money before the rest is distributed. Next, you have someone who may need to include a beneficiary that is not covered under the Distribution Act. As I've explained, if you die without a will, your estate will be distributed according to the Distribution Act. And if the person that you want to make a gift to is not among those described in the Act, they will not inherit. The list of people in the Distribution Act who are entitled to inherit are basically blood relations. This is a table of how your estate will be distributed under the Distribution Act if you die without a will. Okay, so the initial consideration are three categories of people: parents, spouse, and children. Okay, and I put in brackets there, in inverted commas, issue. Why that is done is because even your deceased children or children who died before you, but they died, or he or she died with children, their children will take their share, meaning your grandchildren will take your deceased child's share. So what you have is, if all three categories of people are alive, your parents will get 25%, your spouse will get 25%, and your children will get 50%. So if you have only one child, that child gets 50%. So I've had situations where when my client died without a will, the children was richer than the mother because the children get more. And because it's an only child, the child got double what the mother was getting. If you don't have parents and you have only a spouse and children, your spouse will only get 1/3, your children will get 2/3. Again, if it's a sole child, he gets 2/3 all to himself. So it's set out there who are the people who will inherit. A myth which has been around for a long time is that if you die without a will, the government will take your property. That is not true. As you can see from the table there, there is layer upon layer of people who will inherit. So even if you die without your parents surviving you, without your spouse surviving you, without your children surviving you, under the law, they will still try and find someone who's related to you by blood to take over your estate. And again, I point out to you in inverted commas the word issue. So it's not just the category of person. So for example, if your parents, spouse, and children have passed away and the estate goes to your siblings, if you have a sibling who has passed away, but he has children, then that deceased, let's say deceased brother's children will take that deceased brother's share. So it is actually very remote that the government will actually end up taking over your estate or your assets. Because as far as possible, if they can find a surviving blood relation, that blood relation will take over what is in your estate. Okay, another thing to note is that informally adopted children are not included in your Distribution Act. If you die without a will, the Distribution Act only allows legitimate children. So if it's an illegitimate children born out of wedlock, then it's not, that child is not entitled to inherit. Adopted children, you may also run into problems, something which many lawyers also do not realize is that you have 2 acts in Malaysia under which you can adopt children. And only under one of the 2 acts, only one of the 2 acts allows for inheritance. So you cannot presume that, oh, I've legally adopted the child, so he would be entitled to a part or a share of my inheritance or my estate if I die without a will. So the way around it is to actually have a will so that you can include specifically by name such persons, so that there's no dispute. As I've explained, illegitimate children are not entitled to receive any share of your estate if you die without a will. There are other persons that perhaps could be considered for inclusion in a will. That would not receive any part if you die without a will. I have a client who was practically raised by a nanny because the parents were busy. And now that he's a successful businessman and the nanny who's still with the parents in the house, though not working that much, he was kind enough to tell me to include that nanny in his will, if she's still alive, if he passes away, because he was grateful for the many years that the nanny had taken care of him. There may also be organizations or even missionaries that you have been supporting that you might want to make a gift to. These people will not be able to get a share of your estate if you were to die without a will. Another consideration as to whether you should make a will or not is also to ask yourself whether there is a potential for dispute over the estate. And this is especially when the estate will be large. It would then be advisable to have a will so that there's no dispute as to what needs to be done. Okay, the next question that comes up then would be, if I should make a will, when should I do it? You should do it while you still can, with minimal risk or challenge. You should do it before it's too late bearing in mind that even illness may render it too late for you to make a will, not just that. Of course, after you die, you cannot make a will. But we have to realize that sometimes we can be in an accident, go into a coma. We can be in an accident and we may not be in the right frame of mind. We may be under medication. We may be in pain. All this, if you make a will under those circumstances, you run the risk that the will may be challenged. You may also grow old, or even some people actually have early onset of dementia even before they grow old. And if that's the case, then you may not be in a position to make a will. Or if you make a will, it may be challenged. What are some of the factors to be considered when making a will? First is, whom do I wish to assume what responsibilities? And the first person that we need to think about is the executors. Executors are the persons who will be responsible to determine your assets and liabilities and to appoint solicitors to probate the will. They will have to run around, they will have to attend court, sign documents, etc. So you should find someone who is able to do that. If you get someone who is incapacitated, it may be inconvenient. If you get someone who's old, they may not have the energy. If you get someone who's too busy, they also may not have the time, or they may find it inconvenient. If you appoint someone who's overseas, they may not be able to rush back in time to attend court. It will cost a lot more to have documents sent overseas for them to sign. So for example, if you were to be in London, each signature before a notary public is £100. That's a lot of money. So I actually had a client who, when he saw the stack of documents that he was supposed to sign for his father's estate, decided to come back to Malaysia. He said it cost him less to fly from London to KL, have his fried kway teow over the weekend and fly back, than to pay £100 per signature in London. And so he actually did that. So you have to think carefully who you appoint as your executors. How many executors can you appoint? You can have a maximum of 4 executors at any one time. I usually recommend people to have at least 2 executors. Why? Then you can have a check and balance. Not just one person decides. If there's any decision, they can check each other and see whether that's a wise decision. Secondly, when you have 2 executors, if anything happens to one of the executors, he passes away before your estate can be fully managed, the surviving executor can carry on. But if you have only one executor and that executor dies before your estate is fully settled, you will have to go back to court to have someone else appointed to be as administrator. And that person's powers, authority will be more limited. Whoever you decide to appoint as an executor must be at least 18 years old. You cannot appoint anyone who is below 18 years old. You should also have alternate or reserve executors in the event that any one or more of the people that you want to give priority to are unable or unwilling to act as your executor for whatever reasons. The next category of people you need to think about is trustees. Trustees are persons who will hold your assets for specified or specific persons or purposes. They will pay the expenses for your funeral, manage it. They may be authorized to pay for your surviving spouse expenses or treatment or whatever. That can all be spelled out in your will as to what the trustees are supposed to do. So these trustees can also be appointed to hold your assets on behalf of any of your children who are below 18. And you can even postpone the distribution to your children and authorize the trustees to hold the properties in trust for the benefit of your children until perhaps they reach the age of 25. Because if you were to give them the inheritance at the age of 18, they may be too young and may not be able to handle it. So I have a case where the son was studying in California. After the father died, he suddenly received so much money. He quit university, he didn't complete, and spent his time surfing. So if the property had been passed on to trustees, the trustees could have insisted and say, no, you're not going to get this under the will. I'm supposed to hold it until you're 25. So you might as well complete your degree, then I pass it to you, you can do your business or whatever. But because it was given to him and he was so young, he just quit university and went surfing instead. Again, as with executors, it is prudent to have at least 2 trustees so that you can have a check and balance. You can have the benefit of more than one thinking on any issue. And at the same time, if there's any trustee who dies before the administration of the trust is completed, you still have the surviving trustee who can carry on. Guardians, I've already explained the importance of guardians. So if both parents are deceased or incapacitated, one of them, the surviving parent, it is good to have guardians who will be able to care for your children who are below the age of 18. I've already mentioned to you the wide powers and the importance of guardian, including education and religious education. In deciding on an executor, trustee, and guardian, which can be one and the same person, you should consider the person's age. You don't want to appoint someone who's too old because they may not be able to run around. They may not even outlive you. You should also consider their ability. If you appoint someone who is not able to handle your business or manage your money well, it may not be well invested. It may not be well spent. So you have a pushover as an executor and trustee. If your son says, I want to quit school, give me so much money, they may just give it. So you have to have someone who is that you can trust will do what's right, what's best for the beneficiary. And of course, as I mentioned earlier, availability. If they are overseas, it will be difficult for them to come back to sign documents, to oversee things. Ultimately, the most important criteria, trustworthiness. Whoever you appoint as your trustee or guardian must be someone that you can trust without reservation. Next, you should consider what you have to give. I find that listing your assets and liabilities will help you to determine not only how much is available, but also what is available. You know, I've got clients who come to me and say, oh, they want to give 10% to this person, 10% to that person, and all that. And then when I finally get them to list down their assets, they suddenly realize actually it's quite minuscule once you give to so many people. So listing down your assets and your liabilities, which will have to be paid off, will help you be able to think clearer how much you have to give, what you have to give. This in turn will also assist you in determining how it can or should be divided, and if there are any special considerations in relation to any particular item, person, or purposes. So I've already said, you may have a family heirloom that you want to give to a specific child. And that leads to the question of who do I wish to give or need to provide for? The immediate family, including parents, are the usual people that we need to provide for. However, it is prudent to remember and consider other people or organizations who may be dependent on you. For example, the stoppage of your support for a missionary may have a critical effect on the personal and ministry needs. So if he has been dependent on you to carry on his work, once you die and the support ends, he may not be able to carry on his work. Once you have identified who are the people that you should be providing for, you need to look at how best to provide for them. You need to consider the present and future needs of each person in determining what you give to each person. Ensure that what you give and how it is given is a blessing and does not turn out to be a curse for the recipient. As I mentioned, we have had children who have dropped out of school. I had a client whose daughter, when she received the first check, immediately went to the boss and told the boss, you can take your job and shove it, and walked off. So we need to be careful to see how best to even give out what the person is entitled to. We don't want them to end up destroying their lives. Gifts can be given outright, or it can also be deferred. It can also be given with conditions. It can also be qualified and say that, okay, until they reach a specific age, then hopefully they are more matured and able to wisely manage their affairs, it will be held by the trustees. That has been explained already. And it can be given periodically or even by installments. It can be qualified to be given for only as long as the person is alive. So I have a client who made a will where he had one son who was a full-time worker in the church. At the same time, he realized that he should be fair to all his children. So what he did was, he told me after discussion that the best thing to do is to provide for the family home not to be sold until that son who was a church worker decides he no longer wants to stay there. So while that son wants to stay there, needs the house, the property is not to be sold. After that, they can sell and the proceeds of the sale be distributed. A gift can even be shared and given to more than one person. And you have to consider whether it is wise to do so. For example, if you say, okay, I give our family home to my two sons. And you have one son who is actually given up his Malaysian citizenship and is living overseas. It may end up to be an issue between the two brothers because he doesn't get the benefit. The one who's staying here gets to stay for free and it doesn't get sold. And so it can create friction. It can also create friction when there are needs to repair, maintain the property, things like that. You may also wish to direct your executors to buy something for someone. For example, if let's say you have been giving transport to children to come to your Sunday school every Sunday for years, you may then want to say, okay, I want to give this amount of money for a car or a van to be purchased to take over my responsibility of picking up the children. That can be done if you have a will. You can also set aside money for specific purposes. I have a client who's a cancer survivor twice over. The sister is also a cancer survivor. And she's so grateful to the doctor who attended to them that she has asked for provision to be made in the will for a certain amount to be donated towards cancer research. So you can do that if you want in your will. Where specific gifts have been given, there must always be a catch-all clause in the will for anything else not specifically given. Be mindful that the assets in this clause will constantly change and may be much larger or smaller with time and at the time of your death. So I have a case where a will was drafted in the 1960s and the maker of the will had two sons and so two daughter-in-laws. And so she made the will stating that the two daughter-in-laws will each receive a specific amount. And then, of course, she also made a certain amount to be given to the two sons. And the balance, which she thought was not going to be very much, she said, were to be shared equally by all her grandchildren. So the will was made in the 1960s. When she died in 2000 something, the will had never been updated. When they came to me to probate the will, the children ended up much richer than the parents because the house that was given, one each to the two sons, the cash, that amount that was given to the two daughter-in-laws were just a fraction compared to the other many properties that she had bought between 1960 and the year 2010. So, it has to be reviewed, and the residuary clause giving to the grandchildren turned out to be disproportionately bigger. A few miscellaneous things before we conclude. A will is automatically revoked when a person marries, unless it's expressed to have been made in contemplation of that specific marriage. However, there is no automatic revocation of the will upon the dissolution of a marriage. And the will should be reviewed and revised when divorce is contemplated or upon a dissolution of a marriage. Finally, the need for periodic review. A will is not meant to be a document cast in concrete. It should be reviewed periodically, at least once every 3 to 5 years, if not sooner. any material change in your or any relevant person's personal circumstances, be it physical or financial, or any change in the relevant laws, for example, taxation or government levies, all these will warrant a review of your will. Changes in the economic, social, policy, or political climate may also have effect on the provisions in your will. Matters such as a child having moved overseas or given up his Malaysian citizenship may be material considerations, and you should consult a knowledgeable lawyer about it. Why? Because not all lawyers are familiar, especially in relation to real estate. Real estate in Malaysia is a state matter. Different states have got different rules, different laws. So for example, there are restrictions in a foreigner inheriting property. It's easier for a foreigner to inherit property in Selangor than in KL. If you have property in Selangor or Kuala Lumpur and it's inherited by a foreigner, at the present moment, you don't have to pay any government levy. But if the property were to be situated in Penang, you have to pay a government levy just to inherit the property. And different states have got different amounts that's payable as a government levy. So even lawyers, as I say, many lawyers are not aware of this, and therefore they may not make the right provisions to provide for the best way to deal with your estate. So there may be a waste of money if you end up giving somebody a property in Johor and having to pay 10,000 to 80,000 to the government. Okay. So make sure that you get the right lawyer to advise you, especially when you have such unusual or exceptional circumstances. Okay, thank you. We will now take questions.
Mr. Yap, Susie here. Just now, the last session, you mentioned about foreigners inheriting properties, right?
Yes.
Okay. Like you say, certain areas there'll be certain, depending on where the properties are, depends on the, So, okay, what about? You see, I've got two of my kids. They have given up their citizenship, so they are considered as foreigners. Okay. Now, if I appoint one of them as you see, I've done my will sometime a few years back, and I've got 4 kids, and two of my kids are sons, and I make my sons as executors. Now, one of them is, let's say, is a foreigner. Can a foreigner still execute the will?
Yes, a foreigner can be appointed as an executor, but as I mentioned earlier, you have to consider the practicality. If he's resident overseas, so sometimes, the court date, you are given only 1 week's notice. So whether they can take leave, book a flight, and buying an air ticket at short notice will be very expensive. Okay?
I see.
So
In fact,
it is more a question of whether it is practical rather than a prohibition for a foreigner to be appointed. And another thing to note, since you say your children are now foreign citizens, a lot of people, and you say that you have made a will previously. Did your will state your children's MyCard?
What's that?
IC number.
Your IC number.
Oh, yes, yes. Young IC number. I think so. We do, right? I'm not sure.
Yeah, but they are now no longer
They're
Malaysians.
no longer. Yeah, they are no
Yeah,
longer.
so circumstances have changed. You will have to review it and amend lah. Okay, because one thing which people don't realize, just because you take on another country's citizenship doesn't mean you are no longer Malaysian. Okay, you don't automatically lose your Malaysian citizenship.
Okay.
Sometimes the problem is your children may still be Malaysians. It's just that they have been living out of the country for so many years, they have not changed their IC card to the latest.
Yeah.
And then when they want to change, they may have a problem. So when they want to refer to the will, want to transfer properties, there will be complications.
I see.
Okay. And if they are foreigners, the other problem will also be that you will have, let's say, if you got real estate, we will still need to apply to the state government for consent for them, for properties to be transmitted to them, even as executors. So there will be added complications, added expense.
Okay, but I've got, you say two of my sons, two of them are executors, but one of them is Malaysian, one of them is foreigners. So if the Malaysian can he, execute it on his side?
So what will happen is the other son who is overseas will have to renounce. So then you will end up with just one executor instead of two. And the renunciation has to be signed depending on what country the person is in. It may be troublesome, especially let's say in the US, for them to, unless they go to a notary public, for them to go to the consular office, they may stay very far from Washington, so it may take a lot of time, be expensive. In fact, I have a real life case. The son said, I'm not going to be traveling to Washington with COVID, so everything has been jammed for 2 years.
Yeah, sometimes it's a time matter some factor right? Or during
Not just time, it's also cost.
Cost yeah. Okay, thank you.
Right.
Brother Yao, I'm Fukon from the Life Chapel. I have one question. Can a person make a will without engaging a lawyer or even a will firm like Rock Will?
Yeah.
You don't need a lawyer to do a will. You can do your own will. The question is how well the will is done. Okay. So if you are able to draft it well enough, if you are able to look at the finer points, take into consideration the potential, then if you are confident, you can draft it yourself. But you run the risk if you are not qualified, not competent to do it, there may be problems after you pass away. I mean, it's the same thing as I said, you can appoint people like Rock Wills, you can even appoint lawyers. But as I mentioned at the end, you may need to consider whether that lawyer will be able to do a good job. Because not every lawyer is familiar with estates. Not every lawyer is familiar with the laws and regulations for each different state.
Okay, thank you.
As far as the law is concerned, you do not have to see a lawyer to do a will. It's a matter of whether the will is able to cover what is required.
Yeah, just want to know, can the executor, can a beneficiary be an executor?
Yes.
Yes, can.
A beneficiary can be an executor.
Okay, thank you. to valid. Let's say example, if a will is was written 10 years ago, and then the person passed away. So in order to execute the will, is it very simple as just execute, or there is something like they have to call the witnesses to come in and sign some papers? Is there any what do you call it? Is there any inconvenience involved for a very long written will?
Okay, a will has to be probated before you can act upon it. So you need to apply to the High Court for the court to issue a grant of probate. Only after the grant of probate has been issued by the High Court does the executor have the power to then do what is stated in the will.
Mhm.
So if it's an old will, as I said, the problem is whether circumstances have changed. And as I mentioned in the example earlier, the people who are getting may not be what you had intended 10, 20 years ago, but it's still valid and you still have to carry out what is stated in the will. Okay. Now, as far as the witnesses are concerned, yes, you will have to find the witnesses of the will. They will have to swear an affidavit to confirm that the will was executed in accordance with the law. So if it's total strangers, you may have difficulty locating them. So for example, I recently had a will done under Rock Wills. And the address written on the will was incomplete. So I couldn't find the witness. And when I tried to contact Rock Wills for the address, I had a lot of difficulty with them. In that sense, lawyers are easier to contact because even if the lawyer has left the firm, joined another firm, the bar counsel would have a record of where the lawyer has moved to. And so it's easier to locate the lawyer who is a witness. Even if, let's say, the lawyer has left practice, no longer a lawyer, bar counsel will know about it and they will be able to tell you. So you don't have to waste time and money. In fact, sometimes they can tell you that the lawyer has immigrated. So I had an actual case where I contacted the bar counsel and they told me, oh, this lawyer has immigrated to Australia. She's no longer in the country. So then I could explain to the court the situation.
Do is, oh, we need to do the will. We just go to the lawyers and have it done, and then they advise us to make the schedule instead of put it directly. So you say if there's any updating of the items of property, then it's easier. So I assume that the witnesses should be the lawyers themselves, lah. Right?
I can't comment on the schedule thing, but it sounds risky because you cannot just add to your will.
Oh, is it? But that was how the.
No, as I said,
that's part of the will accordingly. That's part
as
of
I
the
said, under the law, anything below the signature, anything after the signature is invalid.
Okay.
Brother Yap, just a question.
Yes.
You mentioned just now it's better to have more than one person named as either trustee or executor. So if you have more than one person, do they act jointly or they can act independently?
They should act jointly. My practice is to say that they act jointly. So you have a check and balance.
I see. Is there, can they act independently if you allow them?
You can. So I've done wills, where we have 4 executors and trustees, and they can act by a majority. I've also done wills where you can have 4 executors and trustees, but one particular person has a casting vote. So all this, it depends on the circumstances, what is most prudent. That's why when you see your lawyer, you need to be honest with them and to tell them, whether this child cannot get along with the sister or you know, I've got a child who's mentally incapacitated, whatever, so that they can advise you how best to structure your will. So, you know, sometimes you go to lawyers and will writers, you tell them, okay, this is what I want, you know, and they just write for you according to what you say you want. My practice is not to do that. More often than not, when people come and see me and say, okay, this is what I want in my will, I'll just let them go on and tell me what they want. Then after that, I'll ask them questions. And more often than not, by the time I finish interviewing them, they realize that what they wanted is not the best. And I will look at the circumstances and craft a will that best meets their concerns and achieve their intentions.
Hello, Brother Yap. Charlene here. Can I just ask a question concerning someone passed away with a will, appointed to executor? After the grant of probate is obtained already, if they want to arrange for the sales of a property, which has, for example, 5 beneficiaries, and these 2 executors apply to court to have this order for them to, you know, sell the property. So normally in Malaysia, how long does it take for these 2 executors to apply from the time of application until they are given the court order for sale? What is the duration of time like? Thank you.
Okay, in the first place, the first question is whether a court order is required or not. All right. So as I said, depending on where the property is, different land officers have got different rules and requirements. So depending on how your will is drafted and which land office is in, there may not even be a need for a court order. That's number one. Number two, if a court order is required, how long it takes also depends on which court the application is filed. Some courts are faster than others. So generally, KL courts are faster than Shah Alam courts. But you are usually, even in KL, you are usually looking about 2 to 3 months before you get your hearing at the present time.
I see.
And you know, before you can even file your application, you need to get your papers all drafted, and you need to get the consent of all the beneficiaries. They have to swear their affidavits. So if, let's say, the beneficiaries, some are overseas, it may take some time for them to swear their affidavits and get it sent back to Malaysia. You know, you also need to get a valuation report, whether that is, you know, how long the valuers take depends on who you appoint as well. And this is where also, if your will is well drafted, you may not even need a court order.
I see. Let's say, for example, if the property is in Petaling Jaya, for example, just now, brother, you mentioned about in certain place, whichever is the district or what, it does affect the duration of time, right?
Yes.
So did you say just now that under certain places, no court order is required?
It depends on how well your will is drafted.
I see. All right. So assuming, let's say, the 5 beneficiary already agreed to sell, okay, and then they have already come to an understanding of certain price, you know, at certain price they're willing to sell. If that state already been obtained, I understand from what you say that is that an affidavit already been obtained and duly signed by the or the beneficiary. So in this case, is all this already been done, and
Have
now
you got a buyer already?
just say, for example, I already got a buyer. So if they need to apply to the court, so in PJ area, how long does it take roughly?
Well, it depends on, as I said, it doesn't only depend on where the property is situated, it's which court you apply to. So the property may be situated in PJ,
Right.
but let's say your grant of probate may have been issued by the Kuala Lumpur High Court.
Okay.
So then I would think I would apply to the Kuala Lumpur High Court rather than the Shah Alam High Court for the court order to sell the property. So as I said, in Kuala Lumpur High Court, you are looking at about 2-3 months before you get your hearing.
When you say get the hearing, that means what, able to, it's not yet getting the order to sell.
So on the day of the hearing,
Mm-hmm.
in Kuala Lumpur High Court, okay, on the day of the hearing, if everything is in order, the court is satisfied, then they will make the order, and then it's just a matter of extracting the order, which may take a couple of weeks after that.
Oh, I
Else,
see.
let's say in Shah Alam, it is 2 steps. They have 2 hearings. The first one is e-review. Then after that, you get your order.
Oh, I see.
So that's why Kuala Lumpur High Court is faster. The procedure is slightly different.
Oh, okay, I understand. Thank you, Brother Yap. Thank you.
Thank you. Michael has put in the chat box. You mentioned earlier that a foreigner can inherit assets via a will. Is there a minimum value that a foreigner can inherit it legally? Understand foreigner can hold property valued at 500,000 RM.
When you say property, what do you mean by property? Real estate?
I'm referring to real estate.
Okay. It depends on
Bank account, for instance.
Sorry?
Bank account.
Bank account is no problem, because what happens is the executor will take the money and then they will distribute it. So if it's real estate, then it's more complicated, because then you have to apply to the for consent for a foreigner to inherit.
We understand that the foreigner can own properties above 500,000. So if the property is say around 400,000, where do we stand, for instance?
As far as threshold is concerned, we will have to look at which state is in. Different states have got different thresholds. And so let's say some states, even there's no threshold requirement if it's inherited. Okay.
Like in Selangor, for instance?
I think because it's inherited, there may be no threshold requirements. But the thing you have to bear in mind is that all these regulations change from time to time, which is why also it is important to review your will periodically.
So anyone have any last question? Well, anyway, thank you very much, Brother Yap, for this enlightenment on the will writing and why the need for will. To me, as you have pointed out, it is pretty complicated, because different laws and different places and different times. So I guess at the end of the day, it's still best to consult an advocate and solicitor for all these matters, for the latest laws and procedures when we need to when we face with such a situation to do a will or to even execute a will. Would you be okay if any of the participants here would like to contact you further if they need further help?
Yeah, you can contact me, but I'm not here to market myself. So if you have your own lawyers, please do go and see your own lawyer.
Yeah, well, I have Brother Yap's
Yes.
contact. So if anyone needs to contact him directly, please PM me. Okay, other than that, so anyone have any questions for your specific cases?
Mr. Yap, just want to find out how much the charges.
How much the charges? There's no regulation of the charges. So unlike, let's say a purchase agreement, the Bar Council has a scale. For wills, there's no prescribed scale. So it's up to the individual person or drafting the will as to how much they think their work is worth. So as I understand it, let's say Rock Wills has got a base amount, and based on how many clauses you add on, there'll be an additional charge. That's my understanding. I may be wrong, okay? But that was what one of my clients told me. At the end of the day, when he was told, oh, it's going to be so much, he said, wow, so expensive. Then the person who did his will took out certain clauses to reduce it. The risk then is that if you take out the number of clauses to fit the budget, the will may not fit your requirements. So the more important thing is getting the will done to meet your needs rather than to meet the budget. Okay.
Okay, thank you.
As far as charges are concerned, you do have lawyers who will charge very low. I'm sure there are lawyers who will charge these days 300, 500, but you have to be careful what sort of will you get. So I've had wills that end up, you save money when you get it done at that time, but after you die, when they want to administer the estate, then they realize that it's not adequate. So as I explained just now, if your will is properly drafted, you may not even need to go to court to get a court order to sell the property. So one of the clauses that people normally take out for those who charge per clause kind of thing is the power of sale. But when you remove that, then you may have to go to court to get a court order before you can sell the property instead of transferring to the beneficiaries. Cheap may not be sufficient.
Okay, thanks.
Excuse me, Brother, can I just ask a question? Brother Yap, just now you mentioned about this power of sale. That means if in the will there is this clause power of sale, then no court order for sale is required.
It depends on how it's worded. That's where, as I said, it's a matter of you can draft your own will, but whether you are skilled enough to phrase it such that it covers the requirement of the law. So you can have a heading saying power of sale, but if it's not properly drafted, the land office may say this is inadequate. And they don't only look at the clause, they look at the whole will in totality. So if there's a conflict, then you have a problem.
Right.
So in that sense, people think drafting wills are easy, but actually it's not. To be honest, it's not easy if you want to do it well. But the thing is, a lot of people don't have problems. They don't encounter problems because unless you need to sell the property, the issue doesn't arise, is it? So for example, if you are just transferring to the 5 individuals, you don't need to sell the property, then the issue of not having a power of sale in the will doesn't even arise. You don't even think about it. So that's why a lot of people get away with it, as it were, because it has not become an issue. But when something becomes an issue and you look at the will and no provision has been made, then your will is inadequate.
Yeah, understand. So when we apply to the court for sale, order for sale, and there is already, for example, a buyer, but is it necessary to enter into the sale and purchase agreement first before submit for court order for sale?
Okay, generally, my understanding is that you should sign a sale and purchase agreement, which is conditional on the court order being obtained. Okay, because then, because you have to provide the court with a valuation report, the court will scrutinize to see that there's no hanky-panky. So for example, if the property valuation says the property is worth 2 million and your sale and purchase agreement is 1 million, the court may not approve the sale. But if you just get a apply for a court order without any sale and purchase agreement already signed, how is the court going to scrutinize, is it? I don't think the court will give you a blank check and say, oh, you just apply lah. You can sell to anybody at any price. Sorry, they have left, is it?
This thing about the power of sale, actually, if the other way around, is it better to just say, give the identify the beneficiaries, and then in order to not to make the whole case so complicated, get the letter of probate to give the rights for all these beneficiaries, and next time the next step is they want to sell, then or that's not a good idea because the property needs to
personally sell. That's not a good idea.
Yeah, because you want
in terms of cost,
transfer.
In terms of cost, in terms of
time,
and in terms of tax.
Yeah.
The best is to have the flexibility. So as I say, if you don't need to exercise the power of sale, it's there. You don't need to exercise it. You can just transfer it. But when you need it and it's not there, that's when the problem arises.
Thank you so much. Anybody else have any other questions? Okay, this is actually, I think the important issue is more of the need to have a will versus not to have a will. I think that's the most important thing. And if you want a will, then best is to consult a lawyer to cover all our needs, customized according to what we have, who we want to give, and all the details, so that it's easier and it's straightforward. And if we give to the real experts, they will be able to do a good job that is stress-free and probably save us more time and money. Right, Brother Yap?
As I said, if there's no complications, then a simple will may do.
All right. And also, I guess it goes with the fact of the matter is how much are all the estates worth, versus if you just have one.
As I said earlier, if it's a large estate, then it is advisable to have a will. But even if it's a small estate, you have only a single-story house worth 500,000. It may also be advisable to do a will so as to avoid breaking up the family. As I said, you may have a son who's resident overseas and a son who's here.
The
one overseas wants to sell, but the one over here wants to stay.
Yeah, understand. One question about can anyone contest a will other than the fact that the person who writes the will is sane, is mentally strong and good? Can anyone contest his will writing?
Contest the will or contest the will writing?
Contest the will. Sorry, the contents of the will. I mean, like a person writes his will, giving to beneficiary A, and then omitting B, and so B feels injustice, not happy. So
it's always open to contest. There are reported cases of someone saying, "Oh, it was an oversight. My father actually intended to include me, but it was an oversight. All the other sons were mentioned, but I wasn't mentioned." So it can be contested. Whether you win or not is a different thing. So even as I said, you can be undergoing treatment, and someone may unhappy with the terms of the will, may say, "Oh, my father wasn't thinking clearly because he was under medication." So that's a grounds for contesting. Whether succeed or not, will depend on the evidence. It can also be contested on the basis that, oh, my father was in hospital, my sister was the one caring for him, and that's why she ended up with the bulk of the estate because she influenced my father, what we call undue influence. It can also be contested. So there are lots of grounds for contesting. So you need to make sure. That's where I suppose if you get independent people to draft the will and witness the will, then it is it lessens the matters that can be contested.
So in other words, unless there are strong evidence support that supporting to validate the other party lah.
All comes down to the evidence.
Yeah. Okay. Thank you so much. Thank you very much, Brother Yap, for today's talk. We have really got a very good insight of this whole thing. It may be very complicated, but I think at least we know it is very important that we should have a will as long as we have some dependence or some assets in our hand. Okay, so with that, we would like to thank Brother Yap very much, and I would like to thank everyone for attending today's talk. We will try to get this recorded session up at the CBC website, hopefully in the next 1 or 2 months. Sorry, it may take a while, but slowly but surely it will be there. So once again, thank you everyone for attending today's talk, and we hope to see you again next month. We haven't identified the dates, but hopefully we'll get a speaker for next month, and we learn something together. Okay, so thank you very much again on behalf of Cornerstone Baptist Church. Brother Yap, I'd like to thank you and thank everybody here today. So I'd like to wish all of you a very good evening and a very good week ahead. So everyone have a good weekend and see you again.
Yeah, thank you.
Bye.
Bye.
Thank you.
Thank you, Brother Yap.
Thank you. Goodbye. Have a good weekend.
Thank you. Bye.